Hi, everyone. I'm Rebecca Sattin, Chief Information Officer of World Software Corporation, and I want to welcome you to our webinar today. Before we get started, I just want to go over some housekeeping items. Everyone is going to remain muted, and if you have questions, there is a question and answer interface within the GoToWebinar product. So if you could put questions in there, we can take some of your questions towards the end should we have time. And with that, I'm going to turn you over to Ari Kaplan, our host.
Thank you so much, Rebecca. I am privileged to be collaborating today with you and with partners in regulatory compliance for this very timely and exciting webinar. I produce a lot of market research. You may know that I'm an analyst that covers legal and regularly ask questions to corporate leaders, law firm leaders about security. In fact, I just, which will be published in probably a couple of weeks, spoke with legal operations leaders all over the country and asked them questions about security. And one of the things they said was 94% said they had concerns about sharing some of their data, and I saw a huge trend in changes in how organizations are auditing their outside law firms. So I'm privileged today to be joined by Michael Feldman, a founding partner with OlenderFeldman, Jeff Miller, a channel account manager with Arctic Wolf Networks, and Carl Benevento, a member of Partners in Regulatory Compliance, as well as Rebecca Sattin, of course, the Chief Information Officer for Worldox. So what's critical about this issue is actually defining the problem at first. So Jeff, let's talk about this for a second. What exactly is a law firm breach, and what are the signs that your firm's been hacked?
Yeah, well, a breach is, it used to be considered any unauthorized access of data, applications, services, networks, or devices, basically by bypassing their underlying security mechanisms. And notice I said used to be. Newer laws, such as the New York State SHIELD Act, are expanding the definition to include not only unauthorized access, but mere unauthorized viewing of data. So that's kind of a newfangled thing that we're seeing in recent regulations. And breaches these days in more current regulations are also starting to include things like biometrics. Right, a lot of us are unlocking our phones with our finger or using our iris to unlock an iPhone. So biometrics are considered something that needs to be protected just as well as a social security number and a name and an address. So signs that you've been breached, a lot of times companies will complain of slow network traffic or the inability to access files. I did work for one of the nation's largest law firms in the past. And when we went under a ransomware attack, calls were coming into the help desk basically saying, the lawyers were saying, I couldn't access my files, you know, and that was one thing. And then when a dozen of them called within a 20-minute period, then we knew something wasn't right. And our file systems were under attack. And we had discovered that we were under a breach. So network slowness, inability to access files are surefire signs that you've been hacked.
Rebecca, why is it that law firms are the targets these days?
Well, I'm not sure if everybody remembers this, but back in 2011, the FBI came out with a warning specifically to law firms, telling them that they're basically the soft targets for hackers. Ultimately, you know, if a hacker is going to target somebody, if they're going to target a company, they can only get that company's data. Whereas if they target a law firm, the law firm might be storing sensitive information for a number of their clients. So it's basically when they target a law firm, they get all of their clients' data that's not properly protected. And typically also law firms are going to have fewer defenses than large corporations. I think it was 2013 that Mandiant came out with a report indicating that hackers had compromised 141 organizations, 80 of which were law firms. And then, of course, there was the DLA Piper situation that happened several years ago. Ironically, that the news of that broke on the day that I was supposed to give a cybersecurity presentation. So I had a lot more to talk about that day, but they were down for many days.
This is Mike Feldman. I'd add something to that. The other issue with law firms, besides just having information about lots of clients, there's a view that's probably pretty accurate that unlike the corporation itself, which is going to have all types of data, the information that the law firm has about each of its clients tends to be of a more sensitive nature. So I'll use IBM just as a generic example. If you get into IBM systems, there's going to be super sensitive information. There's going to be information that nobody could care about, endless emails about what people did over the weekend, etc. Whereas if you got into the law firm database that represents IBM, you're more likely, or the view is you're more likely to have sensitive information concerning IBM. And then, of course, the rest of that law firm's clients. And going along the statistics, so far, just in 2019, there have been over 100 reported data breaches at law firms. And 2018 ABA, American Bar Association survey found 23% of all law firms had been the subject of a breach at some point. That number is probably going to continue to increase for all the reasons we've discussed, and probably some more that we're going to discuss during the rest of this.
Carl, what makes small and mid-sized law firms so vulnerable to some of this?
The fact that they don't have the necessary money, or I should say the support in place to make sure that they don't have, let's say, a chief information security officer making sure that a security plan is in place. There tends to be a lesser of a firewall in place, security measures, antivirus, things of that nature that are not necessarily going to be quote unquote commercial grade, easily hackable. Plus the smaller firms also have the idea that I'm just a small guy, I'm not going to be hacked, right? And as we know, and as we've started to discuss, that is not the case.
So Mike, it's concerning here. You mentioned earlier some of the issues. What are the legal implications of being hacked? And, you know, Carl just mentioned this. Can the failure to reasonably protect client data and prevent cyber attacks result in some kind of malpractice?
The short answer is yes, but there's a few different issues that pop up here. One, of course, is while we talk about data breach and hack interchangeably, they're not necessarily interchangeable. They're not necessarily identical, I should say. You can have a data breach without being hacked. You can have, most data breaches, in fact, are not the result of hacking. They're not the result of a malicious actor. They're carelessness. Somebody leaves something somewhere. They lose their phone. They send documents to the wrong place. They don't secure the documents, etc. All of which could be considered a data breach. But that leads to the answer to your question is there's a couple ABA model rules out there, 1.1 and 1.6 in certain comments that generally require attorneys to take competent and reasonable steps to safeguard their client data. Those rules typically have to deal with, you know, don't send your client's information to the wrong person. Don't, you know, leave it exposed. Don't leave sensitive data sitting on a bus, those types of things. But it's being used, those rules are being used more frequently now for carelessly handling clients' information electronically, whether you don't have adequate security in place or you send it to the wrong place, you don't encrypt, etc. And I actually have a client who is a law firm who inadvertently gave access to their adversary to their own client's information that was on the system. It was a data sharing system that the law firm had, and unbeknownst to them, and truly unbeknownst to the law firm, by sending documents in a certain manner, the recipient actually had access to more than just those documents. And they actually found out. And there's an ongoing dispute with respect to that. And whether it's technically malpractice or just leads to some sort of breach of contract and a retainer agreement, et cetera, those causes of action are starting to increase. And then, of course, you have the standard business implications. I know that's not actually the question, but to me, they're inextricably intertwined. When you as a lawyer are attempting to get business, if you're losing the confidence of your clients concerning your own security, it's going to be harder to get business. And I can tell you firsthand experience in having certain clients in the pharma industry and certain industries that themselves are very sensitive to data security. They want to make sure before they share data with lawyers or information, almost anything, they want to feel comfortable that the lawyers themselves have adequate security and protections in place, regardless of malpractice. Like that's not necessarily going to give them comfort, recognizing that a lawyer could be liable for malpractice. They don't want it out there in the first place.
Should a firm, this is such an interesting point you bring up, Mike, should a firm consult a lawyer if there's a breach or even some inadvertent disclosure given the current environment?
Absolutely. If you know it yourself, if that's your area of practice or you feel competent, that's fine. You go ahead, represent yourself, but just the way lawyers often get contacted by other lawyers to negotiate a lease, to buy an asset, if there is a criminal law issue, you name it, just because you're a lawyer and you know some areas of the law doesn't mean you know them all. So if you've been subject to a breach, a law firm is no different than any other business in needing to make sure that that breach is handled correctly. And if you know how to handle it correctly, because that's in your realm of expertise, great. If you don't, you better contact somebody who does, and you better do it pretty quickly, because a lot of the obligations out there, like data breach notification laws, which are in every state, and the obligations vary depending on what the breach is, those start coming into play pretty quickly. It's not something that you can kind of dilly-dally about.
In a lot of my research, so over the last 5 years, I've interviewed chief information security officers at corporations and asked them questions, and inevitably, the core problem is a human one, right? People accidentally click, there's a phishing issue. And one thing I wanted to mention, just because I generally like to mention this, I use a service called EncryptMe. I don't have any affiliation or relationship. They're not part of this webinar, but for $2.99 a month, it immediately creates a VPN on my phone, iPad, and computer in any Wi-Fi network. And so for $2.99 a month, I feel like that's, at a minimum, that's a reasonable step to take that would be an issue. Now, so, Jeff, I want to go back to you for one quick second. Mike mentioned some legal implications. What are he talked about practical implications, but I'm trying to figure out, the question is, what are small and mid-sized firms, what is important for them to be thinking about when this comes up?
In terms of an incident response approach, well, the first thing is that plan. The plans are really focused on getting out of the breach, but not focused on PR, not focused on legal, not focused on containing the message to the public. And that's where people are coming up short, is they don't have a unified message to the public. And you've got people on Twitter and LinkedIn and other places bemoaning the fact that they're coming up, and that's causing significant because your reputation is out there. So having a plan is another thing. Where we come into play, or where Arctic Wolf comes into play, is the managed detection and response. So before you even get to the breach, we're actively threat hunting, looking for indicators of compromise, and answering the question, am I being hacked right now? And that way, we shrink the mean time to detect a breach from about 200 days on average to mere hours. And you can imagine, in the 200-day statistic, Ponemon and Forrester, they all have different numbers, but it's around 200 days to know that you've been hacked. What we try to do is shrink that time into hours or less. And you can imagine with layered defenses, getting through a firewall, getting into a subnet, moving laterally through an environment, all the things that hackers do to step through your network. If we can detect that they're in there within mere hours, they're not going to get access to your crown jewels. They're not going to get access to the private information that you store. So that's where we come into play, is to shrink that mean time to detect. And that shrinks the attack surface and the amount of damage that could be caused. But again, just having a plan is the first thing. The plan needs to include IT functions. You have to have continuous monitoring in place, in many cases by law. The New York State SHIELD Act talks about it. The New York State Department of Financial Services talks about it. Pretty much any law out there says that you need to have some mechanism for detecting unauthorized access of data in systems. We translate that to mean having continuous monitoring in place. But again, it's not just an IT issue. The issue of incident response extends to, like I said earlier, legal, PR, having cyber liability insurance as well.
Hey, Carl, we got a question from the audience, and I'd love to get some questions. So we're going to have time for questions at the end, but this seemed relevant at this point. So, Carl, I just wanted to ask you, the question is, has IT grown to such an importance and complexity that we should stop trying to do this in-house? And is the option of an outsourcing IT provider better than doing this in-house? I feel like it would be interesting to hear your perspective.
I think it could definitely be a mixture of both, right? I mean, you have to do diligence with the information, your client's information that you have, right? You have to do everything in your power to keep that information safe, okay? So things such as security awareness training for your employees, right? These are things that you can implement with a third party. These are things that you could go out and do on your own. More importantly, looking to have a cybersecurity program in place, all right? As Jeff knows this, we have a saying in our business, people, process, and technology. You need to do an assessment, and better be done by an objective third party to come in and do an assessment on your business, right? Look at your business processes, understanding your workflow, understand how data is taken in, stored, transmitted, right? Making sure that your team, department by department, understand their roles to keep client information safe. Do an assessment on your technology, right? Does it support the business objectives to keep information safe? Does it reduce risk? Things of that nature, right? You're going to want that done by an objective third party.
Actually, I'm sorry. I just wanted to add that what I've seen among a lot of our clients is that sometimes they will outsource their entire IT function, which certainly gets, if you're going to get an outsourced company to help you go through all of your business processes and all of that and make sure that you're secure, that's great. But what I've often seen is that sometimes they don't leave anybody still at the firm to sort of take ownership of that relationship. And ultimately, it's still on the firm to be sure that they're communicating the right information to that vendor and that the information from the vendor is getting back through the proper channels. And the people at the firm have to be involved in that risk assessment process too. That's a big part of this. So sorry to interrupt.
Well, I do.
If I could, just to get to Rebecca's point, absolutely. You have a smaller firm, you have a small to mid-sized firm. They can't afford to have a full-time chief information security officer, right? But they should have someone appointed as a coordinator, at least someone who's going to be responsible for any of the policies that may be in place, any of the programs that this third party puts in place. And when it comes time, if it does happen, if there is a breach, yeah, you're going to need somebody to be able to run with a playbook, such as an incident response plan, to make sure that the process of dealing with that breach is done appropriately.
I'd add to that, because I do a lot of this, educating, teaching seminars for clients with their information security policies. And while I think it is important to have the expert, using the generic term, to do this stuff in the first instance, to make sure you have proper policies in place, to make sure you have proper training in place, to make sure you have proper technology in place, all of which, are totally different aspects of this. I also think it's important not just to train the people on what to do, but to teach them how to train the people what to do. I find more often than not, if you don't have that in place, the employees are less likely to ask questions. If, let's say, if it's at my end as a law firm, if they have to make a call to a lawyer, they may hesitate in doing so. They don't want to incur the cost. They don't want to get yelled at by someone. You have no right to call a lawyer and cost us money. But if you have somebody in-house who is kind of the in-house person on it, whether again it's IT or HR or whatever it is, they're more likely to go to that point of contact, maybe along the same lines you were saying, and that person then can either answer the question because they've been taught how to teach, or that person can decide, I need to call my lawyer, I need to call my IT specialist, whoever it might be.
I want to step back for a second to address something that both you, Carl, and Mike mentioned with respect to the business implications. So I asked Mike earlier, is this a legal issue? Are you going to get malpractice? You're going to get a claim for malpractice because of a breach? But we didn't really talk about the practical implications of any kind of hack or data breach. So Carl, what are those implications? We've seen lots of media attention on this, but for a small and mid-sized firm, what are they looking at?
Oh boy, there's a lot, right? I mean, obviously financial, but damages to their brand. Even for a smaller firm, employee morale, client confidence, bad press, legal defense and settlements. Last week I just did a panel in Rhode Island with a senior litigator, and if the lack of due diligence on your part can be proven, chances of you settling favorably go down considerably, right? Loss of time, resources for remediation and repair. Even on a smaller network, getting that cleansed, getting your folks back in the office and producing again. There's just a host of things that can affect the business with a hack. I mean, we talked about the incident response plan in place, right? Even if you test the plan through the form of a tabletop exercise, you're going to be ahead of the curve if you should suffer a breach, right? Jeff, you mentioned the Ponymon Institute report before, and one of the things that came out of it for this year, for their 2019 costs of a breach, if having an incident response plan in place and testing that plan greatly reduces the data breach costs more than any other single security process. Something to keep in mind, small, large, or medium, having that plan in place would help. But the implications, I mean, varying depending upon the firm, depending upon the breach, and the amount of information that was grabbed.
Rebecca, we had a fun little conversation a second ago about, is this an IT problem? Should you outsource IT? Thanks to the audience member who asked a question. But is a data breach, is this a legal problem? Is it an IT problem? Is it an information security? Whose responsibility is it? What kind of problem is it for these firms?
Well, ultimately, it's the attorney's ethical responsibility to protect client data. And my background, before I became CIO of World Software Corporation, I spent 25 years as an IT director at law firms. And because of that length of time, I saw, from many years ago when not everybody even had a computer, through now when nobody can get by without having some sort of technology with them at every minute of the day. And even at the last firm that I worked for, there was still a tendency for them to want this to be an IT problem, but it really needs to be, it's the problem of the whole firm. And this goes back to, again, the education and making sure that everybody understands not only what to do to prevent a breach, but if they see something that happens that they think might be a problem, they need to know immediately what to do, who to notify. Certainly if the firm, depending on the size, if the firm has marketing people, they need to be involved. At every level, people need to be involved in responding to these sorts of things as well. So everyone, the firm has a responsibility to just make sure that everybody at the firm, from managing partner on down to person at the reception desk or in the file room, has an understanding of what their role is in this situation to both protect the information and also what to do if something happens.
I'll add to that it's an IT problem and it's a legal problem, simply put, because you have two parts of the equation here. One is dealing with the breach that already occurred, whatever that might be, and second is making sure that you stop the bleeding, whether it's an ongoing breach or it's been out there. So it's remedying the issue, and remedying it, depending on what the breach is, maybe IT, maybe it's something with your firewall, maybe it's been phishing, maybe you're subject to ransomware that you need to deal with from an IT perspective, and then separately it's a legal issue, because as it was just said, there's ethics involved, and do you need to notify clients? Do you need to do something else to fix the problem from a legal perspective?
Carl, I just wanted to point out that there's this QR code on the screen. Can you tell us what
that's
for?
I was just going to wait till my co-presenter was done. So we're offering each participant on today's call 2 complimentary items. One is an informative white paper geared towards law firms entitled Simple Cybersecurity and Regulatory Compliance Strategies to Keep Small or Mid-Sized Law Firms in the Black while Avoiding a Black Eye. And that could be obtained by simply pointing your smartphone on this IR code that you see on the screen right now. We're also offering a free scan of the dark web for any of the firms attending today. If you want to know if any of your firm's data or credentials are currently for sale on the dark web, just send us an email to info@piregcompliance.com. That's info@piregcompliance.com with the subject dark web, and we'll be happy to send you a free report.
This is very cool, Carl, because I was just at a conference on innovation and knowledge management. Professor Gabe Tenenbaum actually put this QR code on the screen of the display in the conference in front of the audience, and you could just simply open up your phone, use the camera, and the camera will just shine on this code, and it should just instantly kind of take you to a page. It's incredible technology. So, Mike, I want to track back to you for a second. Why? What is it? Are you seeing small and mid-sized law firms becoming greater targets of hackers? We talked about earlier the fact that law firms generally have quite valuable data, but what is it about small and mid-sized firms that make them unique targets?
So, we talked about what makes them the unique targets, but to answer your question about, I don't know if they are becoming targets more frequently now of outside hacks. And it may be because a lot of these firms, without the technology or resources, don't even know that they've been hacked, because they don't have in-house IT, they don't have scans done. But one thing where I believe they are suffering more data breaches, again, to distinguish the more broad term data breach from the concept of an outside hack, is their own mistakes. Their own mistakes happen far more frequently, I believe, in the small to mid-sized firms, which itself leads to a data breach, whether it's leaving papers around, sending documents unsecured by email, dropping documents, sensitive documents, even in a regular FedEx package, which, despite what people think, they get lost all the time. They disappear to Never Land and they're never seen again. And the smaller and mid-sized firms are far more likely to engage in what I'll call that type of risky behavior than the larger firms, because the larger firms now are being forced to train and to handle these, if for no other reason, having clients in the big industries who themselves require it. The reason though that I think people are starting to catch on to the small, mid-sized law firm for targets, though, to the extent they are targets and it is happening, is while the small to mid-sized firm maybe doesn't have as much sensitive data or useful data as, say, a Skadden Arps or someone like that, they still have sensitive data from their own clients. They often serve as local counsel in major litigations involving big firms. That's where, for those of you that don't know what I'm talking about with local counsel, where there's, say, a lawsuit in New Jersey and the company's being represented by their big outside counsel that's out of Chicago, the Chicago firm may not have lawyers in New Jersey, so they need to, under law, have somebody in New Jersey who works on the case. That law firm, from a legal perspective, may do almost no work in the case except show up in court. And most of these lawyers who do it from smaller firms are happy to do it. It's an easy pay. At the same time, they may be getting lots of sensitive data concerning the bigger client and the bigger lawsuit. And the bad guys know that. The bad guys know these are the firms that do it, and those firms are going to be less likely to have proper policies and procedures, as well as the IT technology in place to stop the hacker. So, you combine all that, you have probably an increase in data breaches in the small to medium size market, as well as, them being softer targets, as well as still having a lot of sensitive information. Maybe not as much, well, certainly not as much as the biggest firms out there, but, that's why people don't rob banks necessarily, but may go in and rob a small store. There's still money in there, and it's a lot easier to get it.
Easier to get.
Carl, I heard you, so I want to just follow up on something. Mike mentioned scanning, and then you mentioned scanning. Are there other recommendations in terms of minimizing the risks? There are obvious things that Mike mentioned, like not leaving papers around, or maybe not using standardized courier services for sensitive data. But are there specific activities people should avoid, or other things that you typically recommend as someone that's doing this on a regular basis?
So I'll answer that first, and I'm sure people are going to have additional items to add to it. But the easiest ones, the kind of don't do, is don't leave your laptop or cell phone sitting around somewhere. Tends to have sensitive information. Make sure they're both password protected so they're not left open. Never ever use public Wi-Fi. And there are exceptions to that, and there's, using VPNs, and you may have protections, but unless you know for sure that you are good, meaning you have all the right protections in place, the default policy is never use them. It's the easiest place to get hacked. Be aware, and that includes airports, by the way. Be aware of people around you, whether you're sitting in an airplane. I mean, I can't tell you how many times I'm sitting in an airplane and watching a movie or doing some work, and somebody has all their sensitive work stuff open right in front of them. And a lot of it is just be cautious. There's the concept of thinking privacy or privacy first. Really think about it while you're doing it. And that's in addition to the regular things about having a clean desk, not leaving stuff around.
Mm-hmm.
I don't want to take up all the time. I'm sure other people have lots of comments to that.
Also, to take a look at the idea of thinking of putting a third-party vendor management policy in place, right? Look at all the individuals that come into your organization. Even if you're a small law firm, you probably rent, right? So you have the landlord coming in the building, you have the janitorial staff coming in the building, you have potentially an IT company coming in and doing work for you coming in the building, HVAC folks, what have you. The idea of having that third-party policy in place and vetting the folks that are coming into your organization that could have potential access. Yes, and one of the simplest things you could do, simple clean desk policy, something of that nature, right? That would help prevent anybody getting in and access to email, looking at files and what have you.
Jeff, when we're talking about this concept of best practices, of things that people should do, and Mike has been vocal about, right, really identifying and talking about a breach versus anything else versus a hack, what are some best practices if you are breached for actually containing that?
Sure. So I mentioned earlier the mean time to detect that you've been breached is 200 days. That's about 199 days too long. So having a system in place for detection and response, something like Arctic Wolf or other solution. A lot of firewalls these days they call them next-gen firewalls, are coming with methods of containment where the endpoint can essentially talk to the firewall and raise its hand and say, hey, I'm infected. An endpoint being like the antivirus software on the computer. And they can talk back to the firewall, and the firewall can say, I hear you that you're infected. I'm going to contain you within that firewall zone so we don't spread the infection outside of the zone. That's good, but it's not great because there could be dozens or more computers within that single firewall zone that are still able to be infected by a malware-laden system. The best solutions out there have containment capabilities that will lock a system down to itself, right? So even if you have 49 other computers in that firewall zone, you're still not able to communicate with them, or the malware isn't. I would say never turn off the system, as you're going to lose valuable forensic information in so doing, including the contents of memory. And, part of containing a breach and part of the whole response life cycle is figuring out who done it, right? How did this happen? Because rest assured it's going to happen again unless you figure out and get down to the root cause and do that root cause analysis. So if you blow out valuable forensic information, you won't know who done it, and it's going to happen again. If you have to, unplug the network cable, but not the power cable. Again, contents of memory, if you wipe them, you won't get those back. From a cyber perspective, all network traffic should be captured. Any network packets should be stored for post-incident analysis. And it's important to make sure, just in advance from an IT perspective, that you have your logging down correctly. Sometimes most people I talk to have 90 days worth of logs. Some requirements require longer than that, but certainly that period of time surrounding a breach, you have to have network packets and logs from your firewalls, your servers, to do a post-mortem and analysis after the fact.
Jeff, you made such an interesting point about knowing what your peers are doing. In my research of CISOs, it was always so interesting to me that every year they would say, yeah, we know exactly what our third parties are doing. And then when I'd ask about fourth parties, or what they call nth parties, there was complete silence and confusion, and people just would rely on agreements or, the hope method. So, Rebecca, how can small and mid-sized law firms enhance collaboration internally with their partners to ensure the kind of secure environment that Jeff was talking about?
Well, certainly internal collaboration can be enhanced with a document management system. Document management systems allow you to secure data, and you can specifically secure your sensitive data usually by different metadata values. Often you can secure things by client, by matter, by specific document as well. I'm actually a fan of least privilege, although it's something that is slow to catch on in law firms just because everybody is so used to the open system where everybody has access to everything. But my view is that when it comes to client-sensitive data, the only people who should have access to it are the ones who absolutely need it. So document management systems can help you accomplish that. If you're talking about sharing with people outside of the system, there are some tools. At this point, Microsoft is pushing everybody towards their Office 365 ecosystem. And Office 365 and Azure AD have some really amazing tools to prevent sensitive information from getting out of the firm's systems through their security and compliance settings, as well as with Azure information protection. So there are a lot of things out there that I think, especially in the case of Office 365, I think in the case of smaller firms, a lot of them don't fully understand all of the tools that come with that. They just know that they're getting their, locally installed Microsoft Office applications that they've used every day for decades. But all of these other tools that come with it really can assist them in making sure that a lot of that data remains safe.
I think a big problem with law firms along those lines involves, well, two things. One is the teaching and training, because everything that was just talked about are, IT, software, hardware, that's fantastic to use and to have in place, document management systems that have all these, but the people still need to know that it's available and how to use it. Because if you don't, as we're taught here with our new system, if you don't save the document right, if you don't designate it right, all the fantastic features of your document system don't matter. The other related thing, and maybe it's getting a little outside of what we're talking about, but it's still relevant, is attorneys need to start thinking outside of being attorneys. Meaning, I grew up in the practice. Everybody talks about attorney-client privilege and how this is protected and that's protected. And if there's an inadvertent disclosure of a privileged document in a lawsuit, you just call your adversary and say, hey, I didn't mean to produce that. And the ethics rules require that it be returned and destroyed and any notes, deleted. And lawyers tend to trust lawyers with that kind of stuff because there's ethics rules that govern it. That mindset, while true in terms of being an attorney and having another attorney on the other side, is totally inapplicable to the person that's trying to hack into your system, who couldn't care less about attorney-client privilege, obviously. So it's a different type of mindset that also has to go along with all of this technology.
Mike, on that note, are there specific ethical obligations that are associated, in terms of lawyers making choices? You mentioned the ABA rules, are there specific ethical obligations associated with actually proactively promoting security?
I'm not aware of a specific rule as to that, and in fairness to myself, I don't know the rules of professional conduct in all 50 states, and each state governs it separately. So it's possible there's something out there, but there's not going to be a specific rule that says you need to do this. And those rules, even if you're looking at GDPR and laws outside of lawyers, the rules tend to always be based on a more generic concept of having adequate security, adequate protection in place. And the rules kind of have to be that way because the technology and the training that goes along with this is ever evolving. You come up with a lock on your door and then you realize someone can pick that lock. So then you come up with a deadbolt and you realize somebody can pick that. So you come up with a better deadbolt. It's always a back and forth and back and forth. And that stuff's always changing, which circles back, from an IT perspective, you need somebody who knows this stuff because the technology that you put in place 20 years ago isn't, and may have been top of the line, the best thing out there, isn't necessarily the best anymore. As a matter of fact, it's not going to be the best unless your technology was just to keep everything on a piece of paper. Then you don't have to worry about getting hacked. But, and the same goes from a training perspective. So I don't know whether there's a specific rule that says you specifically need to have a firewall, you specifically need to do this, but the conceptual laws, rules, the ethical rules that govern lawyers are certainly in place. that you have to have adequate security and adequate policies in place. What that adequacy means is going to be interpreted differently and is going to mean something different depending on the type of information you have, the degree of sensitive information you have, et cetera.
Carl, have you seen sort of small, minor breaches result in much bigger challenges particularly for small and mid-sized firms?
Yes, and typically the smaller firms just cannot absorb the consequences, right? I rattled off some of the major consequences, obviously, that can be from a financial perspective,
right,
from, customer confidence, bad press, but 60% of small businesses that incur a breach find it very, very hard to bounce back from it, to the point where they go out of business. The larger organizations, they have the money, they have the time, they can throw at the breach and survive. The smaller ones, the smaller companies, smaller firms, they can't absorb it, especially if it's large enough, especially if it involves multiple clients' information being exposed and being used for illegal purposes, right? At the rate that it's happening now, we're seeing it more and more. And again, they're just easy targets, and it has to do with just opening up a careless email attachment, and now you've got ransomware issues within the organization.
So Jeff, once a breach occurs, what are the state and federal breach notification requirements?
It depends. It's one of those answers. So I will say that all 50 states have their own breach notification requirements. It varies state by state. So depending on the state that you work in, you're going to need to go to that state's regulation. What's pretty much common amongst all of the state level regulations is almost unanimously, you need to report upon actual or suspected breach within 72 hours. So you have 3 days once you suspect or know that you've been breached. And they vary here and there, but 72 hours is the most common time frame to notify. And typically the notification has to happen to the state attorney general's office, although in some states, the state police have to get involved. If you're in insurance, the insurance commissioner for that state. Banks and credit unions have to report up to the FFIEC and the NCUA. But for law firms, definitely the state attorney general's office, if you have been breached, needs to know within 3 days. And also depending on the kind of data you have, if there's healthcare related data, the Department of Health and Human Services has to be notified. If it's a massive breach involving more than 500 individuals' records, they put that on the hhs.gov public wall of shame. You don't want to end up there. Anyone can Google your company name and they'll find you on the wall of shame and not want to work with you. So it kind of depends state by state, but 72 hours is the most common time frame for when you've been breached to when you have to notify. I also want to point out, since this is kind of around law firms, and you got anyone who's on this today can Google the ABA Formal Opinion 483, which is the ABA essentially wrote up lawyers' obligations after an electronic data breach or cyber attack. So again, ABA Formal Opinion 483.
Here's what I found.
483 is what I would look at to see what your ethical requirements are through the lens of the American Bar Association.
So Rebecca, you mentioned earlier the idea of using document management and then Mike also mentioned better document hygiene. How does proactive information governance minimize the potential for any kind of breach?
Well, I think we've touched upon this several times today already, but a lot of it has to do with putting procedures in place and policies and things like that But when it comes to information governance, you really need to look at your business processes and look at them with people from multiple departments. I mean, depending on the size of the firm, maybe smaller firms don't necessarily have, you know, a records management department and an accounting department and all these different separate departments. But by looking at those business processes, for example, like the life cycle of a matter that comes into the firm, starting from its inception through the end, at the beginning, you can, you know, it's going to start with a client engagement agreement when a new client comes to the firm. And to me, one of the most important parts of information governance is retention policies. And if you start by stating what those retention policies are in your client engagement agreement, and then follow through on them throughout the life cycle of that, of each matter, that's definitely a good place to start. In my experience, I mean, for decades, I've seen law firms have good practices when it comes to retention policies for their paper information, but it's been a slower process to get those same policies to apply to their electronic information. And the way I've always looked at it is that you may have to store certain information for your clients that is sensitive during the course of time that you're working with them. But once the case has been closed for, you know, X number of years, 7 years, 10 years, if in your client engagement agreement you have already stated that, you know, that after a certain number of years, you're going to get rid of that information or offer it back to the client, you have to follow through on those things. And that minimizes your risk because it's less sensitive data that you're actually storing. Now, in addition to that, I know that there are a lot of concerns that law firms have. You know, they don't like the idea of getting rid of anything, primarily for knowledge management reasons. And I think that in that process, you have to build in a point at which you decide whether a document is going to be important for knowledge management purposes, and build into that process that you're going to de-identify it before it becomes a part of your knowledge management bank, so that way you don't have to worry about the sensitive components that are in that document. So that's, to me, again, you know, I talked about the life cycle of the matter, but that process really has to be done with all of their business processes, that evaluation. And it has to involve people, you know, including general counsel or managing partner. A lot of people at the firm have to be involved because not a single person in the firm knows every step along the way in terms of what has to happen in that course of that matter.
I'll add something, and ironically, Rebecca, I think, started off earlier giving reference to a report by the FBI, maybe in 2011. There's a quote, this is from Robert Mueller when he was director of the FBI in 2012, because it's very pertinent. I'm convinced there are only two types of companies, those that have been hacked and those that will be. And even they are converging into one category, companies that have been hacked and will be hacked again. And I believe in that 100%. Whether it's hacked, it could be a data breach too. As I mentioned, data breaches are more common. But knowing that is likely to happen, a data breach or a hack, data minimization, having less instead of more, is one of the safest ways to minimize damages, meaning it doesn't stop the hack or data breach from happening. Rather, it limits the liability if it does happen. If your house is broken into and all your cash and gold and jewels are sitting there, you're going to lose a lot. If you get rid of all that stuff, keep it somewhere, that might not prevent your house from getting broken into, but it's sure going to limit the damages to you if your house is broken into. And it's the same thing with the data that you're collecting.
Hey, Mike, you have a CIPP certification as a practitioner and a partner at a law firm. Do you recommend that more law firm leaders increase those capabilities?
Yes. I mean, whether it's a certification or not, you know, a certification is some type of standard. It's good. I think the CIPP goes along with the IAPP, which is the organization that provides it. It's a great organization. They provide a lot of resources, but there are plenty of organizations out there and plenty of ways to become familiar. So I don't want to tout one over the other, but I do think it's important to have somebody who understands this, at least understands it enough to know when they need to seek outside help. If they're not going to become an expert, know when you need an expert.
Carl, we're going to leave you with this. How do you see cybersecurity in small and mid-sized law firms evolving?
Three main areas here for that. Number one, these firms have to have a cybersecurity program in place. People, process, technology all need to be looked at and evaluated for risk. The ability to show documented due diligence on your behalf to keep your client's information safe is an absolute must. Two, you have to elect someone to manage that cybersecurity program. While a dedicated full-time CISO is generally, only appropriate and affordable for larger firms, every firm should have someone who's responsible for coordinating cybersecurity. And as we mentioned before too, that coordinator can be attained via third party, such as virtual CISO role. And finally, have a documented and tested incident response plan in place. Even if you test the plan through the form of a tabletop exercise, you'll be ahead of the curve if you should ever suffer a breach. And as I mentioned before from that Ponymon report, having that plan in place and testing it will reduce your data breach costs.
So we have a question. Oh, yeah, no, please, Carl, go on.
No, I just wanted to remind folks too, just as a reminder, if you want to take advantage of some of these actionable items at your firm, the white paper you can download via the QIR code we mentioned before. And also, anyone interested in a free scan of the dark web, all you need to do is send us an email at info@piregcompliance.com, and we'll get that report right out to you.
So we had just a quick question here. Do we tag each matter, and how do we handle purging data on the backups? I don't know who wants to take that particular question with respect to governance on this issue.
I can certainly address the tagging each matter part. And although I can, for the most part, speak for the Worldox product, we have several ways that can be done. We have a bulk archive tool that allows you to feed information. If you can pull a list of matters that have been closed for 7 years or more out of your time and billing system, you can actually feed that information into this tool, and it will take care of either archiving or deleting the documents within that. There are several other ways of handling it as well. And as for backups, that's going to depend on each different system that people might have, and what your policies on how long you keep backups, because that should be examined as well in this context of information governance.
Well, I have provided everyone's contact information on this situation here, and I will look forward to staying in touch. You can also provide you have your QR code reader here that will also allow you to download the white paper. So on behalf of Rebecca, Mike, Carl, Jeff, I want to thank everyone for joining this webinar, and really appreciate the opportunity. And thanks again to Worldox and partners in regulatory compliance.
Thanks, everybody.
Thank you.